Right, welcome back to Inclusive Design 24 2025, brought to you in partnership with our Platinum supporters, Accessibility Cloud and Intopia. You can follow us on Mastodon and Blue Sky, and if you have any questions for the presenters, you can post them there using the ID24 hashtag. Or, as you're already watching this on YouTube, you can post your comments directly into the live chat in the video. We'll gather all those questions for our Q&A, and we'll ask them at the end of the session. A reminder that ID24 is a respectful community, and you can find our code of conduct on the Inclusive Design 24 website. Now, I am beyond thrilled to be joined by one of my old-time partners in crime, Bruce Lawson. Bruce, over to you.
Thank you, Patty Poo. I am beyond delighted to be following you, sir, and introducing our next talk. The law, hey? We never like saying to people you should do accessibility because the law requires it, because they should be doing it because it's the right thing to do. But nevertheless, it is codified in lots of legislation. Our friends in Europe, or our erstwhile colleagues in Europe, have a new Accessibility Act. What does it mean for you? Well, luckily, Head of Marketing at AbilityNet, Mark Walker, and as an associate, Russell-Cooke. I don't know what associate of what.
Russell-Cooke.
Okay.
Russell-Cooke's the name of the firm. Yeah.
Okay. Doesn't say associate what. I assume it is, I don't know, some wet work operative. I assume it's something legal. Lui Asquith will be here, coming to talk to you about the European Accessibility Act. Put your questions in any kind of social media channel or the YouTube, and I will mercilessly put the questions to them at the end until they weep and beg for me to stop. Over to you, Louis and Mark.
Well, thank you, Bruce, and Patrick, and all the help you've given us. And firstly, just congratulations on ID24. It's a fantastic community institution, and it's a pleasure to be here. We're going to run through the European Accessibility Act and what it means for you. And the main points will be highlighted in a second. But the first thing I was going to mention is on screen at the moment, abilitynet.org.uk/ID24-EAA will enable you to download this deck if that's helpful for any accessibility reasons, or just to enable you to follow any of the links that we might mention. We will be mentioning them as we go along, but that might be something that helps you. So, yeah, I'm Mark Walker. I'm the head of marketing at AbilityNet. I've been at AbilityNet for 15 years, so seen lots of different things change in accessibility. The European Accessibility Act may completely change the world, not quite sure, but obviously it's something that we've been paying a lot of attention to for a long time, and I'm interested in sharing with you what we're learning and what's changing as we go along. Louis, we've been working with on this, so Louis, if you'd like to introduce yourself.
Yeah, thanks, Mark. Hi, everybody. I'm Lui Asquith. I work at Russell-Cooke LLP, which is a law firm. I'm an associate within the litigation team, but my expertise lies in public law and regulatory law, the latter being what's relevant here. It's been a pleasure working with Mark and AbilityNet generally on the European Accessibility Act, and I'm looking forward to this conversation. Thanks for having me.
Well, thank you. So we're going to give you an overview of the EAA. I'm going to assume that you may have heard of it, but it's not something you've learned as much about as we've needed to, sort of right in the core of what we've done. But I'm also going to assume that there's some things that you're going to go away and find out. If we skip over in the next 40 minutes, it will be because we're going to tell you where to find the information you need rather than explain everything about it. Going to give a bit of an update on one particular case that's hit the headlines and our sort of take on that and what we think is interesting about it. But then, because it's an inclusive design event, I'm also going to mention design for all in EAA, because I think that might be the orphan element of the conversation often, and you may not even know that that's connected to the EAA. And just a little bit of a heads up on what it is and just give you some guidance on where to look. And also, again, because I'm assuming you're interested in inclusive design, just a bit of a take on where that might fit into your work. in the next sort of phase of change as we go through the EAA being adopted. And as we mentioned, there was plenty of time for questions and answers at the end, if you have any. Just going to mention quickly who we are. So AbilityNet's been around for more than 25 years and worked in accessibility and assistive technology in all that time. We have a large team of accessibility professionals. We work with clients from all sectors. We're based in the UK, but we have clients all over the world. We also have 500 volunteers who go into people's homes and help people directly with their computers, disabled people, older people and others, getting them online and helping them be safe online. We also run TechShare Pro, Europe's largest accessibility conference. Over to you, Louis. We work with Louis because we need some legal advice into our mix. So Louis can tell you what they're already doing with the EA.
Yeah, quite. Thank you. Yeah, Russell-Cooke is a full service law firm. We're based in London, the UK, and we'll come to why a UK based law firm is offering assistance and guidance on a European or EU directive. Many UK businesses are unclear that it actually may apply to them. So the dynamic there is quite interesting, and we'll discuss that. But as you know, I work within the public and regulatory team here at Russell-Cooke, and my job is to try and make an act that's all about accessibility accessible to those that aren't lawyers. So I'll look forward doing that, or hopefully doing that a little bit today. And just before striving forward, I just think it's important to note that anything that I, or indeed Mark, says today is not legal advice, and nothing I say will constitute legal advice. Thank you.
That's probably something somebody should say every time I speak, to be fair. Equally, I'm not a deep level accessibility expert, so I'm not going to try and offer you detailed accessibility advice. I'm going to give you our perspective about how it's affecting our clients and the work that we do with them as much as anything else. So we ran a series of webinars earlier in the year, and the core structure probably stands up, and it gives you a bit of shape to thinking about what you need to know. What does it cover and why does it exist? That then leads to whether you're in scope, and the in scope phrase which you'll hear is important because even if you're not in scope, there may be something you need to do. But if you are in scope, there may be people who agree or disagree about that. And as Louis says, that's not something we're going to offer you advice about. It may be that you're not sure, and that's why legal advice is necessary. The in scope means that there may be a risk of legal issues are coming up. And so we'll have a brief mention of that. We're accessibility people, so we are used to using the Web Content Accessibility Guidelines, WCAG, as the standard and testing against that. So testing whether something passes or fails. And that's not so simple for the European Accessibility Act. It's not as straightforward as, is it WCAG 2.2 compliant? Yes, no. There are other standards to consider. They're also much broader than websites and apps, which we may, certainly in AbilityNet, we're primarily working websites and apps. There is actually a whole section about products and things like kiosks, and there are standards for that, which we'll briefly mention. But we're going to follow that track that's primarily looking at websites and apps. That's the bit that we work on with our clients. And then a final bit I think that people are probably not clear about because we're just getting our heads around this stuff is you need to consider documentation. We probably mean an accessibility statement for most people who work in accessibility. It's not actually called that in the Act, but it refers to it as that. And there are some other documentation requirements that we certainly recommend, particularly if you're in scope, but also if you decide you're not in scope. So there's some documentation stuff just to consider there. And I think if you add that all up together, you're going to find quite a messy picture and quite a lot of sort of rabbit holes you could disappear down. And we certainly, we went across 3 one-hour webinars, lots of questions and answers across all 3 of them. And there were still lots of things that were coming up at the end of it that we were trying to clarify. So have a look at www.abilitynet.org.uk/EAA. That's where we store all of those resources. All of those webinars are available. There's a free guide that you can download and a load of other resources that we've collected. So, and as there are on lots of other places on the internet, certainly most accessibility agencies will be publishing advice and support around the EAA. So we're going to assume that you can find those answers. Please do ask the questions. that we can come up with at the end if you see something you're not sure about. So,
Okay.
are you in scope, and what does it cover? That's Louis. How do you
Yep.
explain that to your customers?
Yeah, no, thank you. So, yeah, the first question that anybody watching this will be asking themselves is, well, does this apply to me? And it's the first question that needs to be answered. And it's ideally the question that you'd seek advice on getting answered, because if you don't and you get it wrong, there is the risk of quite serious implications for getting it wrong. I mean, broadly, the EAA, which is the acronym that we'll be using quite frequently throughout this presentation to refer to the European Ability Act, it primarily is focused on certain products and services that are sold into the EU. And this is why UK businesses might be caught by the EAA, because if you are based in the UK but delivering products and or services into the EU, then the EAA may apply to your business. So it's really important not just to switch off when you see the term EU there. You may still be caught. Whether you're in scope, as I say, depends on a number of things. It depends on what products and services it is that your business deals in. And Article 2 of the directive sets out essentially what is in scope, and it includes e-commerce platforms, ATMs, banking services, smartphones, computers, telecommunication. I mean, the list is extensive. And it's important to review and, as I say, answer the question as to whether it is in scope. The second bullet point in front of you states the exemption. There is an exemption for organisations below 10 people and €2 million turnover. So that is an exemption that you may be caught by as well. So the headline is, if you don't know, find out the answer. And ideally, most sensibly, that would be by obtaining legal advice.
I just want to mention the geography stuff as well. We've been working on this some time, and at TechShare Pro, we've had 3 sessions, I think, over the last 3 years, where somebody from outside Europe has talked about how the EAA is going to change the global perspective. And we're probably most familiar with what goes on in the States, but what's happening in Canada is very interesting. They're tracking and using the EAA as a proxy for their accessibility regulations. That's going to happen more and more, I think, and it's possibly the most comprehensive attempt at accessibility regulation on the planet, but it doesn't mean it's the only regulation on the planet. So wherever you're looking in on this, the core thing is if you have customers inside the European Union who can use your services and buy your products online, then you are almost certainly in scope. Depending on your size, that may exempt you. I've got a list here of the sorts of things that it covers. You mentioned this briefly, Louis. I'm going to read it, and then we'll have a quick a note about what the difference is. So there are products and there are services, and it's important to bear in mind that the regulations and a lot of the definitions and information around this actually falls into either of those camps. They're not necessarily the same in both bits, and we'll come to that when we come to standards. So we have computers and operating systems. If you're selling them, that means if smartphones and other telecommunication devices, but also payment terminals, self-service terminals, such as ATM, ticketing machines, and checking kiosks, TV equipment related to digital television services, e-readers, and similar devices. So with AbilityNet, we've been talking to Sony for some time. I think probably since about 2018. They came to TechShare Pro and said, "What are you doing about the European Accessibility Act?" Because they worked at timelines where their products that are coming onto market need to be designed with these sorts of regulations in mind from the start, over a couple of years worth of production cycle. So this type of product is that sort of hardware, if you think of it as that. And there are regulations which are already in place about those devices, health and safety, for example, or some of the other things you may expect. And there were some existing accessibility requirements. This is really harmonized. You hear the word harmonized a lot, trying to bring together into one place regulations which reflect the needs of consumers inside Europe who may have accessibility needs. So that they're expecting these products to match up to that. On the services side, telephony services and access to media services, Here's where websites and apps and electronic ticketing for air, bus, rail, and water transport start to appear. That's our sort of bread and butter for a lot of us, but because it's about websites and apps, consumer banking services would almost certainly be delivered over a phone to a lot of people. Ebooks and e-commerce platforms, places you actually buy things from, e-commerce platforms. Pretty much everything that you can buy something on is an e-commerce platform in the broad definitions they've got. And then there's specifically something around emergency communication services. This is not the time to work out whether you're in that list. This is the time to see that it's incredibly broad and that there are two big parts: products, services, and a lot of the information that you pick up when you see this difference starts to make sense, that some of it's in one camp and some of it's in the other. So I think, as I mentioned, one of the questions that you have is, okay, what does it mean to be accessible? For any of those things on that big long list a moment ago, how do I know whether I'm going to be legal and compliant, conform with the regulation? I'm going to sort of slip interchangeably into conformance, whether you're matching up to the requirements, or compliance, whether that means you're adhering to the rules, because there are various elements of that that connect. So we will now mainly focus on services. That's because they're primarily the web-based, app-based interface that we're very familiar with in AbilityNet, and I think for a lot of digital accessibility and design people, that's the starting point. But do bear in mind, if that's not the bit that you're in, if you have a lot of questions about e-readers, actually, when we ran our sessions before, the regulations are changing for the content of e-readers, and that's an element which is quite specific under that product section, as well as the platform that are offering, which is the services. There is this technical standard, which you become very familiar with very quickly as you start working on this, because it's the center of the sort of standards question for the EAA, and that's EN 301549, which is European documentation, which has been published. It's actually still in final draft, so it's not yet completely adopted. That's due to happen sometime next year, but it's very clear what's going to be in it. That's happened over the summer, and the sorts of people who are involved in designing what's in it are the sorts of people who've been involved in other accessibility regulations, standards like WCAG and others. So it's an extension of WCAG to some extent, because it's looked at elements of accessibility that relate to that bigger list that you've just seen. It is available for free. You can look at it. You can make sense of it. And in the guides that we've done and others have done, it will refer you to the relevant sections. It's not a simple document. It's got lots of detail in it, and there'll be some questions in there that you can answer about your own website or app, and there'll be some that you're not quite sure what to do and how to test it. So that's where we're at today, really. We're still in that phase where we're working out. We're very familiar with WCAG 2.2 in AbilityNet, and I'm sure a lot of others are. What's the relationship between the two is the classic question that we get asked by people who use WCAG. So just be aware that you're in a slightly grey area just now as things start to become clear as to how those two are going to dovetail. And equally, how are the regulators, which are different in each country? Each country is going to regulate this separately. How will they interpret those standards? Because there are some areas where it may be interpreted one way or another. So we're just beginning that phase, and we'll come back to some of that when we talk about one of the things that happen. And then how to test for it. For us in AbilityNet, our consultants are doing testing every day for all sorts of different clients. Some of them are in scope, some of them are not. So we've adopted those elements that are clear about EN 301549 into our standard testing. There are a few things that haven't been clear, and so they're sort of in the maybe pile. And so our practice as an accessibility consultant is to continually check against that standard, EN 301549, as part of the work we're doing on all of our work, not just doing the WCAG and then doing the EN on the top. It doesn't really work that way in our experience. So we're trying to harmonize that into the sorts of manual and automated testing you will be familiar with, checking that what we're doing will tick off boxes in the relevant places. And I think that for anybody whose frontline job is accessibility, you're possibly already trying to grapple with this, because this is what comes back to you. If somebody says, I need you to check whether my website is okay for the EAA, it will be a little bit more than just WCAG 2.2. Broadly, it's WCAG 2.2 plus not much else, but that's not 100% true. You do need to dig a bit deeper depending on where they fit in that picture of what they're doing and how that fits into the act. So I think, Louis, you've been looking at documentation. I think this is still the iceberg thing, right? This is the one that people have a look at all the other stuff and this is the one you've got to do now, as far as I could tell.
Yeah, it's really important to be on top of the documentation. And when I talk about the documentation requirements for the EAA, I think one of the best ways to put it to any business owner that's thinking about all of this is if a regulator knocked on your door, you essentially need to show them everything you've been doing since you started talking and thinking about this as a business. Regulators want to see action. So even when you haven't ticked all the boxes, illustrating how and when you will be ticking the boxes is really important. You often find, and obviously it's always fact dependent, but regulators are far softer with those that are clearly taking proactive efforts in ensuring compliance. So ignoring and actively resisting, taking steps and asking the questions is where the problems start. But let's roll back. I mean, the first thing to mention is those that are not in scope, and Mark rightly says, it doesn't mean that you don't have to do anything necessarily. If we're talking about being diligent, being fully transparent, although there's no explicit requirement within the directive, declaring sort of your status as a business that's not in scope is a sensible and prudent thing to do. Having a short declaration on your website that you have considered the directive and concluded X is something that is sensible. So if, you know, individuals, regulators, those that are just interested, start going scouting on businesses' websites, services, products, etc., being able to really easily point to the fact that this has been considered and you consider yourself out of scope is helpful. If you are in scope, then there's quite a lot to consider and get sorted. Those on your screen of, I suppose, sort of specific importance. So businesses require an accessibility statement, and within an accessibility statement, you have to highlight if you are relying on any exceptions under the directive. And this is where it can get quite complicated, because essentially whether a business can rely on exceptions, i.e. they don't have to comply for certain reasons, and which part of the directive they're not complying with, obviously needs to be dealt with very carefully and set out very carefully. And also it needs to be considered whether there needs to be sort of several languages applied to the declaratory statement. If you're a business that is offering services, products into a variety of jurisdictions, ensuring that you're illustrated and complying with each jurisdiction is important. And so it may be necessary, as I say, to have multiple declarations available. Internal documentation is important. Having technical documentation, for instance, working through description of products or services, ensuring that you have those test reports that Mark has just been alluding to, risk assessments, and having those risk assessments on file is sensible and prudent. There's perhaps a need for a declaration of conformity. Also, and there's also a consideration, as I say, around whether there's any exception, and there's a specific possible exception under Article 14 that is being spoken about fairly frequently, which is around this disproportionate burden. So obtaining advice and making that clear within any required statement is also important. I'll stop there. I mean, I could go on, but I know that we're short on time today. The headline is making sure that you have your ducks in a row is absolutely crucial, and making sure you have the paperwork as ever on file. So if there is a knock at the door, you're able to produce everything that you've done, everything that you're going to do. For instance, you might even want a roadmap, so you're able to illustrate the process that you're going to take to ensure compliance, if necessary. But one sure way not to comply is not having the correct documentation in place. So please do take that seriously.
Yeah, I think to illustrate that, because you can be not complying by not having an accessibility statement. That's the point to make. And we've pulled out a quote here from Article 13.2, just to show you the sort of language you can expect to find in this Act. Service providers, which is those people whose website or app EU consumers can use. Service providers shall prepare the necessary information in accordance with Annex 5. You can go and read Annex 5, and shall explain how the services meet the applicable accessibility requirements. The information shall be made available to the public in written and oral format, including in a manner which is accessible to persons with disability. Right, so we've got a sort of probably a reasonable picture. In some sort of a more experienced accessibility specialists may well sort of have a very clear idea what a good accessibility statement looks like. Interestingly, under the public sector regulations that the EU published 5 years or so ago before, which is like a precursor to this, it's quite prescriptive in there what should be in a statement. Because this covers products and services, there are some parts of it which are more prescriptive than others. They're not particularly prescriptive under the Act. So you're not going to look for a list of what you say, it's just telling you how it should be, how useful it should be to people. It must be possible for people with disabilities to access it. For example, it's provided by everybody who's in scope. Question mark about whether you should publish it. If you're not in scope, I think we're sort of in the middle of finding out what the regulators think about that. It should be available to the public, i.e. on your website, and it should be kept as long as the service is in operation. I just wanted to show you briefly that that's the type of information you're looking for out there when you have these sorts of questions, and it is in the Act. And here's another one. It may be appealing to say we can't possibly follow the regulations and make everything we're doing accessible because it would cost too much or take too long, or it would fundamentally alter the nature of the work we're doing. And there is Article 14 says the accessibility requirements referred to in Article 4 shall apply only to the extent that compliance does not require a significant change or product or service that results in fundamental alteration of its basic nature. And it does not result in the imposition of disproportionate burden on the economic operators concerned. So those are the two sort of headings you often hear in the naysayer camp, to be honest, is, yeah, but we could just say that because we can't afford to do it. The downside is if you do that, you still have to show that that's true. So you still have to conduct an assessment and have it on your statement that says this is what we think we consider to be a disproportionate burden to be. And Annex 6 provides detailed criteria for the assessment process. And it's worth saying that that's what we're waiting for the regulators to really tell us to some extent is, what's their burden, domestic disproportionate burden, what's the threshold they consider to be relevant. You could claim that it was a certain proportion of your budget or spend or some other thing which is out of proportion to the value of the business to you, for example. They're going to be starting to set some benchmarks for that, we expect, to just illustrate where the lines are for being able to claim this and therefore not have to make your website accessible, not have to make the requirements match. And there will still be a requirement for you to say what you're going to do about the things that you're not doing now, because you were still required to work towards that goal.
And I think as well, Mark, it's important to acknowledge that if you are delivering into several jurisdictions, the threshold may be different depending on the jurisdiction. So you need to be working to the highest standard. Yeah. Imagine the jurisdiction that is going to be, have that high bar and working to that. It's incredibly important that you keep that in mind.
Yeah. We're going to do a quick update. I think this is just useful for you to try and sort of place how complicated this whole legal thing is just now. Is who's making up the rules? What are they doing about them? How are they interpreting it from the regulatory side? So there's a case which has certainly hit the accessibility agencies' websites. If you go to more or less any accessibility agency, they'll be telling you that somebody in France has brought a case against 4 supermarkets, Alcon, Carrefour, A. Leclerc, and Picard Cigières. and that the case is actually made on behalf of people with visual impairments who are unable to use their websites or apps. And I put a link to the news release. That the background to this, I think, is just as interesting as what they're saying, which is that this is a pro bono group of lawyers who work on behalf of disabled people in France, who have issued this complaint directly to the authorities in France. They're set up in a particular way. All the countries are slightly differently organized. This is going to the French regulator, and they've said that these 4 companies are discriminating against disabled people because of the way they can't use their website. And if you read the press release, it actually does tell you what they can't do. And then they're saying that if you don't get this fixed, then we'll sue you. So that via that, I will use the act to sue you, to those supermarkets. Now, the regulator, I haven't seen anything yet about what the regulator's response to this is. So everything you're reading on the internet at the moment appears to be on the basis of this press release being issued and announcing that it's been issued and been sent to the regulator. There's no sign at the moment of how the regulator is going to respond, but that's the sort of update to you, really, is to say we don't know what's going to happen yet, but it's right at the beginning of that. What could the French authorities do? They could sue those 4 supermarkets. They're much more likely to ask them to fix the problems that have been raised and then give them an amount of time to do that. It's not required within the Act how long that is. That's up to the regulator. And they're now beginning to show their colours in terms of how they would respond to that. And it's also not clear, this is, I suspect, more of a trend, which is that advocacy groups for disabled people will see this as opportunities to raise complaints and actions. So I suspect there will be more of them. And I put a link to the news release, but if you look for, Parafor and EAA anywhere on the internet, you'll see lots of versions of this story. I just think it's important to bear in mind that this is right at the beginning of that process, and we're really not clear what happens next. It's clearly a sign that people are going to take action. What we don't yet know is how the regulators and authorities are going to respond to those actions. So, in AbilityNet, we're certainly saying, well, this is interesting, but it doesn't prove that everybody's going to be in trouble. It's simply not reached that stage in the process yet. And Lui, I don't know whether you've seen anything.
Sorry.
I don't know if you've seen anything, from legal side of things. Of course, this is sort of a little bit of a phony war just at the moment, I think, isn't it? You're waiting to see what the regulators do.
Yeah, I think it's at a relatively early stage. I mean, I know that we were aware that there was a request or a deadline for the 1st of September, which obviously is now passed. So I imagine that there are conversations ongoing, but I'm unsure of the current status, but will be eagerly awaiting any update as and when it arises. And I think just to make a more general point, because it's right, we're at the beginning stages of knowing how regulators are going to be approaching enforcement to non-compliance, but all national measures have to be effective, proportionate, and dissuasive. So regulators are going to be responding in that way. So we know that, for example, Ireland has introduced penalties for non-compliance that includes fines of up to €60,000 and potential criminal sanctions there as well. Other jurisdictions might take sort of a more GDPR style approach, perhaps imposing fines depending on a percentage of sort of a global annual turnover or something like that. It won't be necessarily straightforward, but this isn't about trying to spot the lenient jurisdictions. The jurisdictions have a very clear mandate to, as I say, act in an effective, proportionate, and dissuasive way. So you can expect that enforcement won't be necessarily light touch.
Cool. I'm going to jump on. I mean, I think that you'll see lots of fuss about this on the internet, and we just wanted to sort of put that in perspective. There are other cases which I think are about to come through. You do hear little whispers here or there, something about Italy that may be about to land, but this happens to be the first one, and a lot of people are talking about it. So just wanted to give a bit of context. So that's we've done a bit of stick, actually. There's quite a lot of stick in that when we're talking carrots and sticks. And Bruce at the beginning talked about how, regulation and the law gives us a reason to say you must do it. And actually, there's a bit that's in the European Accessibility Act, which is, for example, we didn't talk about this a great deal in our 3 webinars because it's sort of the other side of the coin. It also talks about something called EN 17161, which is Design for All. Now, this is actually deliberately an element of the Act because it complements the technical standards. And it's much more about your approach to building accessibility. Now, this is the other side of the coin, I think, saying, why don't you build things like this anyway? Why aren't you using a design for all approach? Design for all is not a new concept for us. And particularly if you're in the inclusive design world, then there are other versions of that phrase in universal design and others. So, what does that mean and how does it fit with the EAA? It complements the technical standard. So the technical standard says you're not compliant if this particular thing doesn't do this. If you can't do this on your website with a screen reader, then you're not compliant. This says this is how your organization can organize itself so that it delivers accessible products and services as part of its processes. I think this is an interesting thing for the inclusive design community to be aware of, because it's actually what organizations need to do what we want them to do anyway, which is produce better services and products for everybody. That's its purpose. It happens to be explicitly called out in the EAA. It's heavily focused on user-centered design, and that will be good news for anybody in the inclusive design community and the accessibility community, because we all know that's where it starts in terms of best practice. The main goal, as explained in the documentation, is that organizations should research who is and is not using the services and seek to broaden their user base as far as possible. Of course, from an accessibility point of view, we're including people with disabilities or other requirements that relate to impairments in that all bit, but there are plenty of other alls in there that need to be considered. And the other thing is it's a process, it's a management process that mandates evaluation, documentation, and continuous improvement. So this is about how you embed it in your organization, just as much as it's whether or not a particular product or service passes the test. How do you demonstrate that the activities in the standard are actually resulting in the goal, which is that as many people as possible can use your service? It's an approach, and it's documented, and it's established. It's not new within the Act. There's a couple of key areas I've picked out, which you hopefully would recognize from your own work if you're practicing this inside an organization. Is it encourages you to have leadership and to look at planning, not to just treat this as a bolt-on. Get your executive buy-in, set measurable goals, integrate accessibility into your risk and change management, and provide training, including disability awareness, to any part of the organization that's involved in production. Really, that real holistic approach. And think about delivery and evaluation. So apply your inclusive design approaches across the life cycle of the product and the production process. Make sure that what you're doing is compatible with assistive technology. Involve disabled users early and often, and put all of those feedback loops and audits in place that demonstrate in terms of evaluation that you're doing something that's producing the output that you want. And a final point is about what why it all matters. And certainly from our point of view, this community, I'd say this is moving from that compliance element, the stick, through to culture, where the more that we do this anyway, the better it is for everybody. And that's the carrot, really. It's good for any business to be doing this, and there are lots of reasons why, and reducing legal risk happens to be one of them. It's good because it puts the focus on users. We all know that's sort of a number one thing for us. It makes things sustainable and scalable in practice, and it aligns with things like the ISO 9001 and other management standards that your organization is probably already using. This isn't like an extra. It does have a nice dovetail to it. If you're out there and you're in this land, then there's also opportunities, because this is, it's part of EAA, and we've talked about the stick in terms of what your accessibility statement says and all the other things. Maybe this is something good to bring to your organization and say, actually, there's an approach here that means that we're embedding this best practice and reducing that legal risk and doing better things for our customers. It means you can facilitate the inclusive co-design process. It's got those sorts of things built into it. It helps you build frameworks for monitoring and continuous improvement. So I think this has been a missing element in that EAA conversation. A lot of focus on EN 301549 and what it means in relation to work out for the accessibility people. but this stuff's great for changing the way an organisation works and embedding best practice, and it's called out in the Act, and I think that that's a good opportunity for us to think about what it means. I'm going to leave you with one other piece, which is the best article I found so far about EN 17161 Design for All is on the Tetralogical website. There is a link coming to that, but if you type in EN 17161 and Tetralogical, you'll find this great article by Henny. And it's quite comprehensive, and it leads you through some of the points I've touched on very briefly there. And particularly if we're in the inclusive design world, it connects into the accessibility work very nicely. So we've tried to give you an overview of some of the topics that are coming up in EAA, and you'll have, if you've attended anybody else's or seen any other information on the EAA, you know there's plenty out there to dive into. It starts with, are you in scope and what that means to you? You need to think about how you're going to test this and what standards you're using to test, which may depend on the specific thing you do. If you make TVs, they'll be very different to if you run an e-commerce site. The standards and requirements are different. Number one thing I think for us at the moment is that the Act is now live, and if you don't have documentation on your site, you're technically not compliant. Even if your website is not accessible, you've got to start working out how you're going to tell the world what you've got, not got. And I think that's an area that people, it opens the box at that point and says, right, what are we going to say and how are we going to say it? What testing have we done? Those sorts of things. And then the final element that we've added here, the EN 17161 Design for All. I think that that's something for you to go away. Unfortunately, you have to pay for that standard. You don't have to pay for EN 301549, but you do have to pay to download EN 17161. So I just wanted to say that, when you go looking for it, you are going to find a paywall. You have a look at that tetralogical article first and decide if this is something you're going to pay for, because it may be in your wheelhouse to be doing that sort of stuff in your job, and therefore you can ask for it to be paid for. Oh, so I wonder if we have any questions.
We have.
Yeah, wonderful stuff. Mark, do you mind closing down the screen share so we're just floating heads? Wonderful, wonderful. And yeah, sorry, you caught me just off guard, because when you mentioned, yeah, I'm sure we'll put the link to Tetralogical. I believe I am contractually mandated by my employer to actually do that. Otherwise, I will face disciplinary charges. But I'll get Lui to defend me. I'm sure that will all work out. Yeah, fantastic talk. Bruce, have we got any questions? I believe we do.
We do. Lui and Mark, it is customary when I put questions to you to wear my hat of interrogation. Lui, you're a lead person. You know, the
bit of
judges
cross-examination going on, Bruce. Yeah.
Judges put wigs on, and if they're sentencing people to death, they put a black thing. Lola, the last speaker, already had the strawberry hat, so that's not in the equation. Would you like the emoji poo hat or the blingy sequined hat?
Go on, Matt, you choose.
I think the sequins sound an awful lot better than the alternative, to be honest. Thank you.
Okay, I shall put it on and ask you terrifying.
Oh, now I want it. Now I actually want that.
Right. A quick one from somebody called Bruce, i.e. me. Is the disproportionate burden get out a sort of EU equivalent of reasonable adjustment from the Disability Discrimination Act? If you can say that, so it's unreasonable for you to have to make an adjustment, is it a get out of jail free card?
It's actually it raises a really important issue, and it's sort of around the relationship between this directive and sort of domestic legislation. So we're talking there about reasonable adjustment that you find under the Equality Act 2010, which is a separate duty that organisations, service providers have to have in mind and act in compliance with. That is a very separate consideration, however, and it's important not to conflate the two. So no, they're not the same thing, and it's not a slam dunk. I mean, whenever you're applying these tests to any set of facts, it's always, you know, you always have to be very careful when applying it to a client set of circumstances. So it's ensuring that that circumstance is understood, that the correct test is being applied, depending on what exactly is relevant, depending on, you know, what's going on. I mean, we're speaking so hypothetically here, and it may be that both are applicable. You know, it's possible that both could be working in parallel. So I'm afraid it's not a clear-cut answer, and it's certainly not a simple answer, but to me, quite an interesting situation as and when
Bruce,
it arises.
we had a round table with some clients the other day where this came up, and what was interesting is in the public sector in the UK, this is particularly, but it's true, that's been true in the EU generally. That law came in and was adopted pre-Brexit, so it's the same across the whole of Europe. The public sector bodies accessibility regulation. Somebody mentioned that they were told under that regulation that it was the organisation's budget was considered to be the whole organisation's whole budget, and they were a local authority, so their website was, you know, they were therefore told that you've got loads of money. Now they were saying that they couldn't see that lasting because that's just not how it's going to work. But that disproportionate burden thing is for the organisation that you are and the things that you need to do to make your website accessible, is that disproportionate? That's the theory, that's the framing of it. What we're waiting to see is what those standards are. You know, if you're a large banking organisation that works across Europe and has, you know, several 100,000 customers using your app, and you're saying you can't put alt text on your images when they're using the buttons, that's not disproportionate. You know, that's the sort of reading I would take at one extreme. A small organisation being asked to completely replace everything it's got and put new functionality in place, that's the other end, I suspect. So that's the scale. And the get out clause thing, you still have to do some work. That's the thing that we're saying to people. You need, if you say, I declare disproportionate burden, you can't just put that on your accessibility statement and walk away, because then if somebody finds that and asks you why, then you need to have some evidence that suggests that you've worked out what's wrong, and secondly, why you didn't fix it. So you know, you're already on a roadmap anyway towards getting it sorted. So we're saying, well, that's just the beginning of the process then, because why would you not fix the things you can fix? And it is seen as a get out clause. It's got some very specific requirements in it in the Act that you will discover are going to mean that you might just want to do a bit this way anyway. So I think that's what's going to happen.
Got it. Thank you.
Bruce, I would just add to that, you know, when you're applying this test under Article 14, let's say, you know, a business concludes and is advised that it does apply. That doesn't mean that it will necessarily apply in a year's time or 2 years' time or 3 years' time. And I think it's important for businesses to remember that this is a live obligation, and just because it might not apply in 2025 doesn't mean that that's the blanket conclusion for the whole lifespan of their business. So it's important that businesses are reviewing and taking advice, not just the one time. Obviously, we're urging businesses to take all of this very seriously and seek that initial advice, but just a word of warning, you know, that this is here and it's here to stay, and businesses need to stay proactive moving forward. It's not just a one-stop shop situation.
Super. Now it occurs to me that as there are two of you and I've got two hats remaining, I can go for the other one anyway. Mark, a couple of times you've mentioned we're waiting to see what the regulators think. Does that mean we're waiting for court cases and seeing people get frog marched into dungeons, or are we expecting regulators to produce guidance to say what they think? What actually is, how will we find out what they think?
The first thing to do is just paint a picture of the mosaic of regulators that we're talking about. So in each country, they have chosen how to adopt the implementation, or, you know, who's responsible for it. And that is different in most countries. So an example in Ireland is that the telecoms elements of it will be adopted by the telecoms or the Ofcom equivalent. So it's not another regulator. That regulator exists, but there are some elements to the regulations which are new, and a new body will be checking and surveillance and monitoring across that. So it's a patchwork in any given country. I've heard somebody from Ireland speaking to somebody from Sweden who are broadly in similar roles saying they are required to connect together and harmonize across countries. They have got to harmonize, like if they're both working through the same telecom regulator, then that needs to be harmonized as well as across how they approach it. But that doesn't mean they have to do it the same way. They simply have to make sure that if I see your website in Sweden and I think it doesn't do something and I tell you what you've got to do about it, you would expect to get a similar response if you were hauled up in Ireland. Not that there's different responses and different, you need to fix this bit in Ireland, but you need to fix something completely different in Sweden. That's what we're aiming for. But you've got these multiple bodies trying to connect up on something which is new for most of them, and which is technically, like EN 31549, doesn't technically exist yet. So you're just in this funny sort of period of people saying, well, how do I know that that's passed or failed? And then the regulator's saying, well, this is how we're interpreting that. And then another regulator in another country saying, oh, our take on it was this. So I think it's more the messaging. I don't think any of the regulators that I've heard are jumping in to try and frog march down the street. Their stock response I've heard is, we want to make them compliant. We want them to be accessible. That's our goal, not to end up in court, wrapping their knuckles. That's because they didn't do what we asked them to do, rather than because we found something that was wrong. Find something that's wrong, tell them what's wrong, expect them to fix it, give them one life, and then we'll decide what we're going to do about it. That's why it's going to take a while to see where those different bodies are acting in across different parts of the regulations.
Super, thank you. Thank you very much, Mark. Thank you very much, Louis. That was really informative. Extra legislation. I'm glad I don't make or sell anything. Thank you both very much. I want to thank Patty Poo, for inviting me once again to guest host. I do love me a bit of ID24, and I do love me a bit of Patty Poo. So thanks very much, Patrick.
Thank you.
Yeah. No, thank you once again, Mark and Louis. As I said, I've been fanboying about your presentation ever since I attended it a few weeks, months, whatever. Time has no meaning. So yeah, I was really delighted that you agreed to present here as well. So great stuff. But yeah, we're running short on time, so I will wrap it up now. So for the audience at home, if you like this session, hit that like button, like and subscribe, so you're kept in the loop on all our future events. Inclusive Design 24 is brought to you with thanks to our Platinum supporters, Accessibility Cloud and Intopia, our Silver supporters, Intuit, and our Bronze supporters, the Law Office of Laney Feingold, Mantis & Co, and Vispero. ID24 will be back on the hour in just a few minutes, so see you there, and thank you all.
Don't touch that dial.
Don't touch that dial, kids.
Thank you very much, both of you. That was cool. Thanks, Louis.
And hopefully I wasn't too intimidating with the hats.
I'm just too jealous to be intimidated. I mean, that's not the second one, definitely. I'll keep that one.
They're available to hire in court if you want, Louis.
yeah, get a bit sick of a wig, actually. It'd be a nice breath of fresh air to take in a poo hat.
Right, now we all freeze frame.
Yeah.
All right, everybody. Thank you very much.
Thank you. Take care.